What's up, everyone? This is Kenny here from Property Stories. So today we're going to talk about how to evict tenants the legal way. Okay, if you are looking for creative ones, illegal methods, you can click off this video because you will not find any. Before we move on, I want to explain that I am not a lawyer. Okay, I am not a lawyer, so do not take this as any advice. Okay, I'm just sharing my experience as a real estate negotiator and an investor. Okay, and what I've got actually speaking to lawyers, speaking to other investors who are actually doing the same. Okay, so I'm just going to share with you the overview steps. Okay, and then after you take and apply it. Okay, hopefully you don't need to use it, but this is something that you can have and know without at least if something happen you will know what to do. Okay, so let's start. The first one is to have a valid tenancy agreement. Okay, of course you need to have a valid tenancy agreement, meaning the tenancy agreement need to stamp. If it's not stamped, can it be used? Can, but if you want to admit to court, you need to stamp first, and when you stamp, at least they will charge you a penalty before you can admit it to court. So might as well get your tenancy agreement stamp. Okay, so tenancy agreement is actually a legal contract. Legal contract here means it must be drafted by a qualified lawyer. Okay, I know there's a lot of tenancy agreement template online. You just Google, you can get template. You use that, it's a risk on you. Okay, another source of tenancy agreement is also the real estate agency. You know, even real estate agents, we are already reminded in the circular by Bovia, the board, we call them board, our regulators, that real estate agents or real estate agency cannot prepare a tenancy agreement as it's a legal document. So what the agency does is that the agency will appoint or get a lawyer to do a tenancy agreement for us. Okay, and that one, a registered real estate agency will have that tenancy agreement ready for you. Okay, drafted and done by a lawyer. It's a proper legal contract. Having said that, the dangers of using the DIY tenancy agreement is that you don't know the terms. That's one. The second, yes, you might have loopholes that the tenant can actually make use of. If the tenant know how to use the loophole, then you're in for a long fight. It's no longer about property, it's about legal litigation. And I've seen before a tenancy agreement, right? It's like one page. Sorry, 2 pages. That's it. You know, that is totally really out, and everything is so vague and it's one-sided to the landlord. I've seen before this kind of tenancy agreement. Then I don't know how, but I suspect both tenant and landlord also just sign in here. Never read also. Okay, so please do not do that. Make sure if you are renting out your property, make sure you go through a real estate agency. Okay, if you don't want, you say I don't want to pay the commission, I don't want to go through real estate agency, no problem. You can achieve pay a lawyer. You need to pay, of course. You pay a lawyer to do for you the tenancy agreement. Okay, and contract drafting, right, is separate from conveyancing. Conveyancing, you have a scale fee. Contract drafting is a separate skill, and there's no scale. Okay, one lawyer can charge you don't know how much, but the other lawyer can charge you differently. But you will that means you will know that this is actually legal and you are protected. It's fair. The tenancy agreement, basically it must be fair, not just to one party, the landlord, but landlord and the tenant. Okay, so that's number one. Number two, if let's just say a tenant default already 1 month, default here is not like you don't pay at all. Even you pay half or any partially is also considered default. Okay, let's just say the rent is 2,000. The tenant say, okay, this month I only pay 1,000. I got no money. That is considered default here. You can issue a notice of termination. This notice of termination, you don't need lawyer to issue. You can just go ChatGPT or go online Google, type a draft. There's just a simple notice saying that you're terminating the tenancy based on the tenancy agreement signed on what date, and you will forfeit the security deposit of the tenant. You can only say that, and then you want to get the access card and the keys, whatever it is, from the tenant for 14 days of this letter. Just send over WhatsApp. Sign and send over WhatsApp. Okay? Also can. So by 14 days, the tenant need to move out. And if you actually appoint an agent, if you have an agent to take the keys from you, you need to specify in the termination notice. Okay? Put the agent's name and the rent number or the registration number there, because the agent is the one that's going to collect the access card and the keys. Okay, remember this, when you issue the tenancy agreement termination, and you appoint the agent to collect the keys and card, that's exactly what the agent will do. You did not appoint the agent to evict the tenant or communicate with the tenant on this eviction. You understand? Okay, do not confuse when the agent agrees to do this, the agent have agreed to collect only the keys, the card, and inspect the place for you. Okay? It's not to actually make sure the tenant to go out. No, that is your job as a landlord, because that's the agreement is between you, the landlord, and the tenant. The agent has no picture. You're appointing somebody to on your behalf to go and get the access back to the property. That's it. Okay? And we have agents also have no power to go and barge in to that property, even though you tell us it's okay. No. Because you know what happened? The tenant can sue us for trespassing. Understand? So be very clear when you appoint an agent, it's just to collect for you the keys and also inspect the property. But if the tenant choose not to meet the agent or miss the appointment, you have to step in. And you are the one, as a landlord, need to remind the tenant, hello, tomorrow is the date you need to come out from the house. Okay? You come out from the house and liaise with this agent. So please contact this agent, tell this agent the number, when are you coming out. That's it. And pass the access card, the keys to the agent. That's it. Stop. Okay? There is, and agents, you also need to remember, agents, you are not enforcers, you are not police. So do your work, do within the boundaries of the law. Okay? If anything, you go in there and inspect, right? Imagine this, if you go in there and inspect and then the tenant just complain. Let's just say complain that you molest or what, or crime happened inside that house. Are you going to be responsible? Crime, no. Now, it just give you a scenario, some very, very imaginative, but likely to happen scenario, okay? So here, you landlord is appointing you, right? You go and inspect the house. Say you go and inspect the house, then say there's only one person there and you, okay? Or a few people there and you. Imagine this. Then let's just say few girls there. Then suddenly, these girls say you molest them. How? You go and inspect the house. Suddenly this kind of thing turn into a criminal case. Are you going to, who's going to be your witness? Do you understand where I'm coming from? Or this common one, when you go and inspect a house, then the tenant already know the tenant is need to forfeit their deposit, all this. Okay. Then the tenant will just show you, you see, this one not working, this one not working, that not working, want to negotiate security deposit. Even though, yes, security deposit is supposed to be forfeit when the tenant actually move out. The tenant didn't pay, default. Right? You guys want to negotiate, you just can wreck the house, man. Okay? And just say, oh, okay, this one is not I do one. You come, then it's happen. Can, right? You go in the house, you and the tenant inside. Tenant wreck the house. You see, this one your agent do one. Then the landlord ask you, are you going to be responsible? So agents, remember, do your job. Also, you need to think. You need to think of how to do your job according to the law and safeguard yourself from all this. So my advice to you is to always know your role. Meaning, you take your the keys and access card. That's it. This one is an eviction case. It's not like a normal handover. Normal handover, okay, you need to go there, you need to do your work, take photos, everything, because the landlord is supposed to return back the security deposit to the tenant. Okay? Then you have supposed to do your work. But this is an eviction case, so don't play a fool. And then this is not even the tenant that you brought in. Even if it's a tenant that you brought in, you are not in the agreement. Okay? You are not in the agreement. So why will you put yourself at risk like this? Just make sure that the person meet you at a public place like a guardhouse. Okay, just wait there, collect. That's it. And when you collect, right, how many access cards, how many keys, you make sure the person sign there. That's it. So when you do your work, make sure you know how to safeguard yourself. Money is money, but learn how to safeguard yourself. Okay? I talked so long already. Let's go to the third one. The third one is that if let's just say you go and leave 14 days and then the tenant don't move out, so what's next? Usually, right, we don't straight away fast to go to legal action. There are a lot of ways to navigate the situation, for a better word, but I cannot actually talk to you about this here. Okay, so you go and talk to anybody else that you trust, especially a lawyer. You can go and ask a lawyer, okay, because they will be able to advise you better. Okay, because then if all else fails and you have to go to legal, then let's go to legal lah. Okay, this is the final last resort, last kind of thing. So then you go to legal. When you appoint a lawyer and pay them the fees, the lawyers will proceed to apply for a writ of distress from the court. Okay, so how much to pay? That is a very good question. I've been trying to ask so many lawyers, none of them want to quote me. So I was asking myself, why the heck is it so hard to quote? It's just a legal quotation. Then some of these lawyers actually explained to me, Kenny, it's not that we don't want to quote you, but actually there's many situations. In my mind, I thought that this is that property case. So why not just follow the property scale fees, right? But actually no, I was wrong. You want to evict a tenant, right? It's under litigation, criminal litigation already. Litigation here, so they have to refer to a few specific acts, number one, and depending on the situation, number two, they have to choose what are legal actions to put inside, okay, to apply for the writ of distress. So actually, the lawyer also don't quote me, because he said can be depend like how many months outstanding, number one. Like, what do you want to? There are two ways to think about it. You still want your rental, but allow the tenant to stay, or you don't want the rental, you want to forfeit the rental, you want a vacant possession. It's different charges. Okay, how long this, how bad how severe the case, what happened in between you and the tenant until from day one until now. Maybe halfway you do something funny. Then what happens? You need to. So the lawyer actually will need to assess it on a case by case basis. It's not straightforward, because I also understand where they're coming from. Litigation, there's no scale, and the more complicated the case is, the more you pay. Okay, so I asked them to give a ballpark value. Frankly speaking, it's not worth your rental. It's like even some lawyers actually they tell me, Kenny, all these small and you go and slow talk with the tenant. Because when you come and hire us, we definitely have to charge you so expensive one. Then I asked them, so what kind of monthly rental need you do? Oh, actually we monthly rental anything if it's less than 10,000 we don't do usually. We do mostly 10,000 above. I said, wow, like that. Yeah. They do mostly like those commercial, commercial areas. Those, if let's just say commercial area, from a shop lot, let's just say 10,000 a month, or retail lot 50,000 a month, that kind of tenant and landlord dispute. That one they come in. So these are the big kind of lawyers. Okay. Although that being said, right, there are also lawyers who also do for 2,000-3,000 rental. They don't care how much the rental is, As long as you are willing to pay, then yes. Okay. So there are 7 steps to apply for a writ of distress. They will have to prepare and file the writ of summons for writ of distress, then extract the sealed course paper, attend hearing on case management, go to court, attend hearing. That's where all your money goes. So okay. So I just want to explain to you like what are the work involved behind the scenes. Okay. Extracting the sealed writ of distress after approval from the court, right? Then you execute the writ of distress. Then to execute, they meet to the bailiff. Meet the bailiff, the court bailiff. Okay. This is where sometimes, right, people take matters into their own hand, which is wrong. You see, when the court actually grants you the writ of distress, you as a landlord, right, or all the tenants increment, everything. That means the court actually grants you back the case, and if you win the case, you can get back your vacant possession of the house. So some landlords, after they go and meet the bailiff, then the bailiff will need to give you the date appointment. So sometimes the date appointment can be like 2 weeks later or 1 month later, depending on the bailiff availability, right? So these landlords, thinking that they already have the writ of distress, they go to the property, their own property, and evict the tenant themselves. You get in trouble. You will get in trouble. The tenant can sue you for trespassing. Okay? The tenant can sue you for criminal intimidation. The tenant can sue you for multiple things. Can sue you, criminal intimidation, trespassing, and then denying their rights to live peacefully based on a tenancy agreement. So many things they can sue you for. Because you didn't wait for the bailiff. Okay? So after meeting the bailiff and get a date, you execute the writ of distress with the bailiff. Okay? That means your lawyer and the court bailiff, okay, bailiff will bring maybe police, 2 in uniform or 1 or 2 in uniform, to go to your property. If you are there, but if not, the lawyer also can do it for you. The lawyer will do it to get the tenant out of the house. Okay, once the tenant is out of the house, inside there, whatever things inside, assuming you didn't provide fully furnished, then you provide basic and the tenant furnish it. The bailiff will 1 by 1 label the items and then go and auction off. After everything is done, the bailiff will lock the house. Only the bailiff has the authority and the power to lock the house. It means to execute the writ of distress on behalf of the court. Okay? So after that, then only we can talk about getting back your house. Okay? So how long this process will take? Fastest about 2 to 3 months. Fastest 2 to 3 months. And fastest 2 to 3 months, and I'm sure you'll be asking me how much it's gonna cost. Ballpark figure. Ballpark figure. I can tell you your 2.5 months deposit in some cases it's not enough. Okay, let's just say your rental is 2,000 a month. So 2.5 months is 5,000, right? But in some cases not enough. Okay, so you have to get the lawyer and talk to the lawyer because like I mentioned at the earlier start, there's many ways to go about it without going to the court. The court is the final avenue. Okay, let's call you final boss. That one you cannot beat one. Final unbeatable boss. This one. Okay. So what's the significance of a tenancy agreement? Okay, let's just say you don't have a tenancy agreement. The process take back that house, even though it's yours, it's going to be longer. Okay, it can take up to 6 months to get back your house. So make sure you have tenancy agreement. So when should you actually think about all this? Knowing that it's going to cost so much. The moment tenants forget or didn't pay, don't care. As long as don't pay the first month, they straight do all this already. I'm not talking about the court part. I'm talking about reaching out to whoever it is that you talk to, especially a lawyer. Tenant don't pay 1 month itself. Okay. In most cases, right, I understand that they are first time landlord very reluctant to go through this process because they are waiting and hope that the tenant will pay. I can tell you, hope is no point. Hope won't pay your mortgage. Only the real rental payment will pay your mortgage. So don't delay. The longer you delay, the more you will lose. you only hold 2 months security deposit. If the tenant don't pay for 4 months and you need another 3 months to get back the house, I give you another 4 months or 1 month, you try to slow talk, you try to do everything, right? 4 months plus 4 months is already 8 months, 8 months, you got no rental. How long you want to keep the house? Instead of adding money to your pocket, now it's draining money to your pocket. Okay? Long story short, this is the summary. First one, you must have a valid tenancy agreement. Second, notice of termination, you can issue to the tenant. Third one, you can appoint a lawyer. Okay? The lawyer will apply for you writ of distress. So actually, there's only 3 steps. Very simple. Okay? Those are the 3 steps that you can take to evict errant tenant. I hope this sharing has been useful for you, especially those who are first-time landlords. You're not sure what to do about this when your tenants start not paying for a month or already more. You are not sure what to do. Okay, I hope this helps you. This is Kenny here from Property Stories, and I will see you again next video. Bye-bye.